Well, as I mentioned just before we went on, for people that do what I do, which is typically defense work, both public and private officials, Massachusetts has just enacted, well, soon to be implemented, 2 new laws. So for us, it's sort of the gift that keeps on giving, because you can rest assured there will be some litigation that flows out of these 2 pieces of legislation. First, the Equal Pay Act, which is somewhat of a misnomer, but that's the way everybody refers to it. I believe that goes into effect next month, or April, and also what's called the Pregnancy Act, which is, there is a federal pregnancy law already. In a nutshell, you can't, as an employer, public or private, take any action that would be an adverse employment action simply because someone is pregnant or needs some accommodations due to the pregnancy, things of that nature. It sort of fills in a void between the federal law and other federal laws, like the ADA, the American with Disabilities Act. If it's conceivably, you could have a very difficult pregnancy, or under the FMLA, where someone requests up to 12 weeks of leave under the FMLA. I think what the state law, as I say, sort of fills a void that at least our legislature thought needed to be covered between existing federal law and what is a new state law. Okay. The Equal Pay Act, as it's commonly referred to, is just that. I mean, this is a really interesting piece of legislation for a number of reasons. Since I'm a defense attorney, I'll start with the more draconian provisions. I mean, this is a strict liability piece of legislation, which is rare in Massachusetts. Basically what the law does is wants to even the playing field between men and women, and so that they receive equal pay for similar, comparable work.
Right.
Now, the Attorney General's office is supposed to issue some regulations to give some guidance, if you will, as to what that means.
Define similar work.
Define similar work, define comparable work. What does it mean if you're on a trading desk and you make a lot more than someone else next to you, but you have the better customers? How does something like that play out in this piece of legislation? So the AG's office has not issued the guidance yet. When I mentioned draconian, it calls for if a public employer or private employer is found liable, that is, some pay disparity between men and women, then it is liable in damages for up to double damages. And the finding is when I strict liability, what I meant is if the Office of the Attorney General, whomever it is that comes in to do an investigation, finds that Acme Inc. Has discriminated against men and women, even if unintentional, it just evolved over the years that there's a disparity in pay for no particular reason, without design, without intending to. There's no defense.